California Civil Procedure Handbook Rules, Selected Statutes and Cases, and Comparative Analysis. Chapter 7, as Chapter 6, Discovery, might have been read to YouTube already. Resolution of cases before trial. Summary judgment. Summary judgment generally. California practice employs the motion for summary judgment, which includes a motion for summary adjudication as a potentially powerful procedural device to probe beneath the pleadings. Pleading motions have limited utility. They accept the facts, or at least the well-pled facts, contained in the pleadings as true in testing the sufficiency of claims. Except for a novel or badly pleaded cause of actions, a technically skillful pleader will state proper causes of action. Nevertheless, the claim or defenses made to the claim in the pleadings may not be factually substantial enough to warrant a full trial. Summary judgment is the means for weeding out causes of action and defenses that lack merit because they are factually unsupportable. The purpose of summary judgment is to penetrate evasive language and adept pleading to ascertain the presence or absence of triable issues of facts, from Molko v. Holy Spirit Association. As in the case in its federal rule equivalent, Rule 56, FRCP, California's motion for summary judgment is extensively regulated by statute. The awkwardly numbered Section 437C of the Code of Civil Procedure now takes up almost 3 pages of an unannotated code book, all in fine print. The statute has been regularly, almost annually amended, but its principal standards have remained constant. Any party may move for summary judgment in any action or proceeding if it is contended that the action has no merit or that there is no defense to the action or proceeding. The motion shall be supported by affidavits, declarations, admissions, answers to interrogatories, depositions, and matters of which judicial notice shall or may be taken. The motion for summary judgment shall be granted if all the papers submitted show that there is no triable issue as to any material fact that the moving party is entitled to a judgment as a matter of law. The corollary motion for summary adjudication is used to test the merits of one or more specific causes of action, one or more affirmative defenses, one or more claims or damages, or one or more issues of duty. CCP 437C. The relationship between the motion for summary judgment and the motion for summary adjudication is roughly equivalent to the relationship between the general demur and the motion to strike at the pleading stage. 2. California's burden-shifting approach. Moving parties' initial burden. Pursuant to a trio of recent California Supreme Court decisions, summary judgment practice in California now confirms largely, if not completely, to its federal counterpart under Rule 56 of the Federal Rules of Civil Procedure. See Salesler v. Advance Group from 2001. Aguilar v. Atlantic Richfield Co. From 2001, Goose v. Bechtel National from 2000. In Salesler v. Advance Group 400 Supra, the Supreme Court described the burden-shifting approach to summary judgment after the 1992 and 1983 amendments of the CCP 473C as follows. Under the current version of the summary judgment statute, the moving defendant need not support his motion with affirmative evidence negating an essential element. So let me read this again. A moving defendant need not support his motion with affirmative evidence negating an essential element of the responding party's case. Instead, the moving defendant may point to the absence of evidence to support the plaintiff's case. When that is done, the burden shifts to the plaintiff to present evidence showing there is a triable issue of material fact. If the plaintiff is unable to meet her burden of proof regarding an essential element of her case, all other facts are rendered immaterial. It quotes from Leslie G. v. Perry and Associates of 1996. Subsequently, in Aguilar v. Atlantic Richfield Supra, the Supreme Court again endorsed the burden-shifting approach to summary judgment described in Salesler. Oh, well, they spell it differently now. Salesler, Aguilar, Supra. However, the Aguilar court further explained that The summary judgment law in California now conforms largely but not completely to its federal counterparts. Summary judgment law in the state no longer requires a defendant moving for summary judgment to conclusively negate an element of the plaintiff's cause of action. In this particular it now accords the federal law. All that the defendant need do is show that one or more elements of the cause of action cannot be established by the plaintiff. Citing 473C subsection 02. In other words, all that the defendant needs to do is show that the plaintiff cannot establish at least one element of the cause of action. For example, if the plaintiff cannot prove element X, although he remains free to do so, the defendant need not himself conclusively negate any such element. For example, himself prove not X. This is in line with the purpose of the 1992 and 1983 amendments, which was to liberalize the granting of motions for summary judgment. The defendant has shown that the plaintiff cannot establish at least one element of the cause of action by showing that the plaintiff does not possess and cannot reasonably obtain needed evidence. The defendant must show the plaintiff does not possess needed evidence because otherwise the plaintiff might be able to establish the elements of the cause of action. The defendant must also show that the plaintiff cannot reasonably obtain needed evidence because the plaintiff must be allowed a reasonable opportunity to oppose the motion. Summary judgment law in the state, however, continues to require the defendant moving for summary judgment to present evidence and not simply point out that the plaintiff does not possess and cannot reasonably obtain needed evidence. In this particular, at least, it still diverges from federal law, for the defendant must support the motion with evidence including affidavits, declarations, admissions, answers to interrogatories, depositions, and other matters of which judicial notice must or may be taken. This just seems completely contradictory to the last sentence I just read, which said summary judgment law in this state no longer requires a defendant moving for summary judgment to conclusively negate an element of the plaintiff's cause of action. And now it says, after that sentence, all of this is coming from Aguilar. It says summary judgment law in the state, however, continues to require a defendant moving for summary judgment to present evidence and not simply point out that the plaintiff does not present evidence and not simply point out that the plaintiff does not possess and cannot reasonably obtain needed evidence. So it no longer requires conclusively negating an element of plaintiff's cause of action, okay? But it does require defendant, moving party, who happens to be the defendant, to present evidence and not simply point out that the plaintiff doesn't have any. Okay, that's not divergent. I don't know why that got so confusing. In this particular, at least, it still diverges from federal law, for the defendant must support the motion with evidence, including all those things I just read. The defendant may, but need not, present evidence that conclusively negates an element of the plaintiff's cause of action. The defendant may also present evidence that the plaintiff does not possess and cannot reasonably obtain needed evidence, as through admissions by the plaintiff allowing extensive discovery to the effect that he has discovered nothing, but has, as Fairbank and Wonderman Cato Johnson 2000 concludes, the defendant must indeed present evidence, whereas under federal law, pointing out through argument may be sufficient. Under state law, it is not. So that's all I read from Aguilar. How significant is the difference between requiring a moving defendant to present evidence as opposed to simply pointing out through argument, identified in Aguilar Court? For a discussion of this question, as well as a review of California summary judgment law after the Supreme Court decisions in Aguilar, Salzer, and Goose, the California Supreme Court speaks out on summary judgment in its own trilogy decisions. How has the Celotex era arrived? A Santa Clara Law Review of 2002 is a good secondary source. There's also Kids Universe vs. Into Labs of 2002 discussing the burden of production language in Aguilar. burden shifting, and factually devoid discovery responses. Several cases have held that a defendant may rely on factually devoid discovery responses to sustain its burden as the moving party on summary judgment. See Union Bank v. Superior Court. Summary judgment for defendant appropriate where plaintiff's answer to interrogatory requesting all facts that would support plaintiff's fraud claim merely stated plaintiffs believed defendant had engaged in fraudulent conduct. McConnell v. Kasem Gypsum of 2002, defendant met a summary judgment burden in wrongful death action for occupational exposure to asbestos based on deposition of plaintiff's decedent showing plaintiff could not establish causation. Rio Linda Unified School District v. Superior Court of 1987 states summary judgment for defendant school district was appropriate in a personal injury action because disregarding inadmissible hearsay in a deposition to which the defendant objected, the plaintiff produced no evidence that minor plaintiff had in fact fallen from a slide on school property. The extent to which a defendant may rely on factually devoid discovery responses to sustain its summary judgment burden was clarified in Shinding v. Dinwiddie Construction Co. of 1999, decision quoted with approval by the Supreme Court in Saylor v. Advanced Group 400. After extensive analysis of the recent amendments of 437C, the Shinding Court concluded that the defendant must show from the plaintiff's discovery responses that the only reasonable inference is that there is no further evidence available to oppose the motion. In other words, defendant's initial burden is not met by merely showing that based on the discovery responses currently in the record, there are no facts to support an essential element of plaintiff's claim. Instead, the defendant must show that the discovery questions were directed at an essential element of plaintiff's claim, and based on plaintiff's discovery answers, the only reasonable inference is that the plaintiff can produce no further evidence to support this essential element. Defendant failed to meet its summary judgment burden based on deposition of plaintiff, where plaintiff refused to answer questions about the essential element of plaintiff's cause of action. Summary judgment procedure. Summary judgment motions are permissible 60 days after a general appearance of the party against whom the motion is brought. CCP 437CA. Notice of the motion and supporting papers must be served 75 days before the hearing date, subject to extension when service is made by mail. Opposition papers must be served 14 days before the hearing, and reply papers 5 days before the hearing. Section 437CB. The procedure for supporting and opposing papers is elaborately set out in Section 437CB. There must be separate statements setting forth plainly and concisely all material facts which the moving party contends are undisputed. Each such fact must be followed by a reference to the supporting evidence. The opposing party must provide a separate statement that responds to each of the moving party's undisputed facts, agreeing or disagreeing with the characterization, and must set forth any other material facts as that the opposing party contends are undisputed, along with references to the evidence. If either party has evidentiary objections to the other's summary judgment evidence, they must be made at the hearing or they are waived. For a detailed explanation of the form and format requirements for summary judgment and summary adjudication motions, see Rule 3.1350 of the California Rules of Court. So subpart B of this section is called default judgment, and right now we're looking at a five parts of detailing default judgments. Part 5 being a really long case. But I can read at least the first 4 parts. So 1, default judgments generally. 2, general procedures. 3, procedures in personal injury actions. And 4, statutory restrictions on default judgments. Before we get to 5th, relief from default judgment, relief sought within 6 months. That one has the Beeman case. For default judgments generally, a plaintiff may obtain a judgment by default against a defendant properly served with a complaint or summons or a cross-complaint who fails to timely file an appropriate responsive paper. CCP 585 and 586. Likewise, a defendant may obtain a default judgment against another defendant or a plaintiff properly served with a cross-complaint and fails to timely file an appropriate responsive paper, again from Section 585E and 587.5. Slightly different citations of the CCP. An appropriate responsive paper under CCP 585 includes such items as an answer or demur and a notice of motion to strike or transfer, or quash the service of summons, or to stay or dismiss an inconvenient form. Relief limited to demand and complaint. Default judgments entered against defendants or failure to timely answer properly served complaints are commonplace. Most such default judgments involve routine procedural issues easily resolved by reference to the appropriate code section. Code of Civil Procedures 580, for example, directs that the relief granted to the plaintiff, if there is no answer, cannot exceed that which he or she shall have demanded in his or her complaint. Section 580 embodies a fundamental due process notice requirement from Marriage v. Lipple of 1990. A default judgment greater than the amount specifically demanded is void as beyond the court's jurisdiction, and supported by Greenup v. Rodman of 1986, Becker v. SPV Construction Co. of 1980. Part 2, General Procedures. The procedures utilized to obtain default judgment are also fairly routine in most cases. After the applicable time specified in the summons for responding to the served complaint has expired within 30 days after completion of service, in most actions under CCP 41220A3, the plaintiff must make written application to the clerk or the court for an entry of default. CCP 585A through C. The plaintiff must complete and file the request for entry of default form Civ 100 adopted for use by the Judicial Council of California, along with the proof of service and return of original summons from CCP 585A through C and 417.10 through .30. Entry of default. Generally, under the procedural scheme set forth in CCP 585A through C, an entry of default is a prerequisite to a default judgment. These two concepts are often lumped together, but are actually two different steps in the default process. When the defendant or cross-defendant has not filed an appropriate response paper within the prescribed time, the plaintiff or cross-plaintiff may request the court clerk to enter the default. Until the time of such entry, the defendant may ordinarily file a belated response without consequence. But the entry of default terminates the defendant's right to file an answer or take any other affirmative steps in the litigation until either the default is set aside or the default judgment entered. See Devlin v. Kearney Mesa, AMC Jeep Renault Inc. of 1984. Entry of default precluded defendant from participating in subsequent proceedings to determine amount of punitive damages. Forbes v. Cameron Petroleum Inc. in 1978. A demur or answer filed after entry of default was an illegal nullity. Obtaining default judgments. After entry of default by the clerk, the plaintiff or cross-plaintiff may apply for entry of default judgment. In some actions, the court clerk has statutory authority to enter a default judgment, such as an action on a contract that provides for a definite fixed amount of damages ascertainable from the contract, and then only if a defendant has been served other than by publication. That's CCP 585A. In all other cases, the plaintiff must apply to the court for a default judgment. This includes all actions not based on contract or on a judgment. CCP 585B. Actions based on a contract or a judgment where the damages or the attorney's fees are not fixed. In all actions where service of summons was by publication. 585C. Why does 585 require a court judgment as opposed to a clerk's judgment in these type of actions? There's just more likelihood that justice can be averted in those situations where you posting notice by publication or the fees are less determinable, so the clerk does just not have the discretion that the judge does on fees. Procedures for a court's default judgment. Section 585 is supplemented by local court rules. Specifies the procedure by which a plaintiff may obtain a court judgment. The plaintiff must apply for the relief demanded in the complaint, and the court shall hear the evidence offered by the plaintiff, and shall render judgment in his or her favor in such sum not exceeding the amount stated in the complaint and the statement required by 425.11 or in the statement provided for by 425.115 as appears by such evidence to be just from CCP Section 585B and C. To prove up the default for the court, the plaintiff need only introduce evidence sufficient to establish a prima facie case. Morehouse v. Wainzo, 1968. Casordas v. United States Tile and Composition Roofers of 1960, where the complaint states the cause of action and the evidence introduced establishes a prima facie case, the court must enter the default judgment. And again, we're citing Morehouse v. Wainzo. They're also citing Taliaferro v. Hughes of 1963, where the court properly refused to enter default where plaintiff offered no proof of damages sustained. Procedures in personal injury action. In an action brought in superior court to recover actual punitive damages for personal injury or wrongful death, the process of obtaining an entry of default is a little more complex. Complications may arise in such actions because the plaintiff is statutorily precluded from stating in the complaint the dollar amount of actual punitive damages demanded. And that comes from CCP Section 425.1.10b and Civil Code Section 3295E. Consequently, the plaintiff must serve on the defendant a statement of damages setting forth the nature and amount of damages being sought before the default may be taken. CCP Section 425.11 Personal Injury Damage and 425.115 Punitive Damages. This statement should be served a reasonable, usually 30 days time before entry of defendant's default and must be served in the same manner as a summons. CCP 425.11d and 425.115g. Failure to comply with these requirements precludes the entry of default. Schwab v. Rondell Holmes, Inc. of 1981. Does the complaint which specifies the amount of personal injury or punitive damages in contravention of CCP 425.10 provide the requisite notice for a default judgment? See Uva v. Evans in 1978, upholding validity of default judgment where plaintiff's complaint specifically requested $30,000 in general damages for personal injuries contrary to Section 425.10 despite failure to serve a statement of damages. Cummings Medical Court v. Occupational Medical Court of 1982 upheld a default judgment entered for the amount of punitive damages alleged in a cross complaint. 4. Statutory restrictions on default judgments. Various specific statutes impose additional procedural restrictions on the entry of certain default judgments. For example, CCP Section 764.010 prohibits entry of default judgment in a quiet title action unless the court hears evidence of the plaintiff's title and of the claims of any defendant. Section 1088 prohibits the granting of a writ of mandamus or prohibition by default and requires such cases be heard by the court whether or not the adverse party appears. Family Code Section 2336 prohibits the default judgment in the dissolution of marriage or legal separation proceeding and requires proof on the grounds alleged presented by the court by affidavit or personal appearance. Certain persons are also statutorily protected against judgment by default, regardless of the nature of the action. The most notable such protection is Federal Soldiers and Sailors Relief Act of 1940, United States Code, Section 501 and sequential, which generally seeks to prevent the entry of a default judgment against the defendant who is in the military service. See Interinsurance Exchange v. Collins of 1984, where the court clerk's refusal to enter a default on ground that plaintiff did not submit a signed declaration of defendant's non-military status held improper. Federal Act protected military personnel from default judgments but not from defaults. So when we return, we'll go into the Beeman v. Berlin case about relief from default judgments, relief sought within 6 months.